Good morning, sir. You speak English? Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 10th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling at a high rate of speed, failed to signal a lane change, weaving in between cars, and following too closely behind other vehicles. The law enforcement officer matched the defendant's vehicle at approximately 100 miles per hour. A traffic stop was conducted, and the law enforcement officer made contact with the defendant, who stated he did not know.
Wait a second, the driver admits he didn't know his speed? That's like saying, I wasn't lost, I just didn't know where I was. What do you think, honest mistake or a reckless excuse?
He was going that fast.
Okay.
And if I could, Your Honor, just real quick, basically we had the opportunity to look at the videos. My client has a radar chip in his car. We've shown that in the state. His car wasn't going over 90 miles an hour, and he clearly using his indicators. And on the video, the officer says that he doesn't know how fast he was going. His car has no radar, but he thinks it's 90 to 100 miles an hour.
I mean, you're going through video. This is just probable cause hearing. We could set it for something, but
There is no actual speed that he paced my client. So there is, just to let you know,
speeding in and out of traffic, falling too closely.
according to the officer, right?
So I'm going to find probable cause for
That's
now.
fine.
We can always set it for, because I have to give them the
No,
opportunity.
absolutely, Your Honor.
No.
Absolutely. I
So
think the chief, once he's, done with this trial, he's already told me it's going to be either a class dismissal or straight up dismissal.
Sir Albazan, I'm going to find a probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in this manner again. If I find that you drive at speeds of 90 to 100 miles an hour, doing reckless driving, weaving, I'm speeding, I'm going to revoke your bond and put you in jail. Just, we have enough crashes on the road. Don't add to it. You know what I mean? No reckless driving, racing, street takeovers, donuts, nothing of this matter. Got a great lawyer. He's going to help you out. Stay in touch with him. We'll give you guys time to work on the case. I'm going to have bond conditions created so you promise us that you're not going to drive like this. If I find that you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay, so we'll have you sign a reset. Just have him take a seat. We'll get bond condition created, and then once you sign it, at that point, you can leave. Leave. Hey, Cole, can I borrow you real quick so we can do PC real quick?
Yes, Your Honor, of course. My apologies.
This is Mr. Bias. B.A.
Oh, Mr. Pickens?
All right, Mr. Bias, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
This is wild, 120 miles per hour in a 60 zone. That's not just speeding, that's practically drag racing with commuter traffic. Should judges crack down harder on cases like this, or does the bond system already keep them in check?
Can you get the name one more time, please?
Let me give you a cause number.
Yes, sir.
Tell me when you're ready. 256
256.
0257.
257. All right, thank you, Your Honor. On April 15th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling on the Gulf Freeway. The officer visually estimated the motor vehicle speed to be between 115 and 120 miles per hour in a 60 mile per hour zone. The officer attempted to catch up to the vehicle and observed approximately 15 to 20 lane changes from across all 4 lanes of traffic around other cars that were obeying traffic laws. The officer had to travel at speeds in excess of 120 miles per hour to catch up to the defendant's motor vehicle. Officer caught up to the motor vehicle and paced it at 115 miles per hour for approximately 1/4 mile. A traffic stop was conducted, and the defendant stated, "I effed up."
Run his license, please.
Yes, Your Honor.
Mr. Bias, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive in this manner anymore. If I find that you're a danger to my public, it's not going to go well for you. Do you understand?
Yes,
I will revoke your bond, put you in jail, no more PR bonds.
Yes, sir.
The license is open.
You are not allowed to drive unless you have valid Texas driver license and liability insurance in your name, and that is a condition of your bond. If I find that you do, or that you drive without, likewise, you will go to jail. No more PR bonds.
That's all.
We are going to reset your case to give you time to hire a lawyer. I'm going to have the state create bond conditions that you're not to drive in a reckless manner. You're not to participate in a racing street takeover, donuts, anything of this nature. I will do everything in my power to protect my city at all costs, Mr. Vice, and I want you to understand that. And if I find any more of this, it's not going to go well for you. Do you understand?
Yes, sir.
Do you mind filing those conditions, Cole?
Yes, sir.
For now, I'm going to have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. Once you have signed them, then you'll be free to go. Please. You are Mr. Billings.
Yes, Your Honor.
Mr. Billings, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high level of alcohol. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 7th, 2024, in Harris County, Texas, officers responded to a motor vehicle accident. The officer arrived and observed two vehicles that had been damaged and rendered inoperable. The defendant was ID'd by his Texas driver's license and ID'd to be the sole occupant and driver of the motor vehicle. The officer relocated the scene to a nearby parking lot to safely conduct the investigation. The officer determined the defendant was at fault for the accident after speaking with all the parties involved.
0.17 blood alcohol. That's more than double the legal limit. And the defendant said he had 2 beers? Sure, buddy. What's your call, lifetime license suspension, or do you believe in second chances?
And reviewing information collected at the scene. The defendant stated he had left a bar called Sugar Room. The defendant stated he drank 2 beers at the bar. The officer noted that initially the defendant was not even aware that he had been in an accident. The officer observed the defendant to be lethargic and confused. The officer observed the defendant to have slurred speech, glossy eyes, and trouble maintaining their balance. The officer had to ask questions multiple times to obtain simple information from the defendant. The officer did not notice alcohol emitting from the defendant despite defendant's admission to drinking and defendant's apparent physical and mental impairment. The officer suspected the apparent impairment of the defendant could have been caused by some kind of narcotic. The defendant refused to perform standard field sobriety tests. The DIC was read. The defendant agreed to provide a blood specimen, and the lab results came back to a .17.
Okay. Any prior to DUIs? And does he have a
first.
and valid license?
Judge's license was recently suspended ALR. He will not be driving. He has a 90-day suspension.
Okay. I want you to understand something, Mr. Billing. I take this extremely serious. I don't care what you have to do in your life. If you do not have a valid license and liability insurance, you are not allowed to drive, and that is a condition of your bond. You will be signing an affidavit with me today promising you're not going to drive. I don't care if there's a burning building and you have to say 50 kids. Do not drive. Do you understand?
Yes, Your Honor.
Nothing you can say justifies getting into a car and driving. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If you get called upon to go take a test and you fail to go, a warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Okay. But now I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you'll sign a reset. After that, you'll get to Roxanne where you will get your bond conditions, and then you're free to go.
Thank you, Judge.
Yes, Your Honor.
Please. Oh, I don't know. Wait a second. Bond? Is he on bond? Did he make a bond?
No, Judge, we're asking for PR bond. I thought you said you granted the PR bond.
No, we haven't. I assumed that, no, I haven't given PR bond.
Yes, we're asking for the PR bond. He was not arrested.
It's a two.
Okay, come up, Mr. Billing. I didn't realize that. Thank you for saying.